So the first set of questions, I think, relates generally to compliance and filings in what I would call the ordinary course, and how government and regulators are looking to address those filings and ordinary course registrations, given the fact of COVID-19, right? Now, the general position, I would say, is that there are already a number of extensions which have been announced. So, for example, under the Companies Act, they've said you can defer the date of your general meeting. This is, of course, relevant only to Section 8 or erstwhile Section 25 companies. But even under the Societies Act and the Trusts Act and the rest of it, while those regulators are not the most prompt with these kind of clarifications, we can anticipate that there will be an element of flexibility which is afforded. What you must do in each case, right, and this depends on the type of organization you are. If you're a company, Ministry of Corporate Affairs is quite clear and you're relatively okay. You can follow those guidelines and timelines. However, if you're a society or a trust, get in touch with your local state level regulator, drop them an email, ask them what is the revised timeline, or is there a revised timeline or something like that, and take it forward from there. Now, let me make it clear. I would not be surprised if some of you were to tell me that, we've already raised that query with our local regulator and we haven't received a response. That may not be unusual, right? Because also, in addition to us being under stress, let's be clear, government at the end of the day is also people, and they are equally under stress and things are perhaps a little tied up. So you may or may not get a response, or you may or may not get a timely response. But the important thing is, if you've already raised a concern today and you've put that on record, going forward, if someone seeks to impose some kind of adverse action against you, you have something in your favor to say, hey guys, I'd asked this question. I was doing everything I could, but real circumstances prevented me from doing things on time. And therefore, now you cannot, impose a penalty or do other things to me. And I want to reiterate here that the importance about these flexibilities attached to filing and the rest of it, you need to be able to demonstrate, and that's the importance of this email or letter. Letter, I think, doesn't work in today's world anyway, but of email or other written communication, is to demonstrate in the future that at the right time, I had put my hand up, I had said, guess what, I have a problem, and I do need your help in addressing it. Today, when we talk about it, this may not seem particularly relevant, but take my word for it, and those of the NPOs with whom we have worked on such issues in the past, not around COVID-19, will understand what I'm saying when I speak about the importance of a contemporaneous record, right? It's crucially important, especially when you're seeking these kind of flexibilities. Okay, so to summarize the general position on flexibility and compliance in the ordinary course, track what your regulator is saying. Right, Ministry of Corporate Affairs, Ministry of Home Affairs if it's FCRA, your state level regulator for trusts and societies, etc. Right, and to the extent you have a question, there's a genuine difficulty you have, of course, try and get in touch with them. Most government offices are functioning with skeletal staff, but someone should be around to take the phone, and irrespective, get something in writing with the relevant authority in the best way possible. That would be a general principle which I would think applies across the board, and you need to pick that up as you need to. Okay.